Hi, this is Carrie with Carrie Concealed in the Active Self-Protection Extra channel, and today we're going to discuss Old McDonald's EIO principle, and we're going to put it into action.
Lucky Gunner is my recommended trusted provider of freedom seeds for range or defensive use. In stock, good prices, and rocket-fast shipping are why I go back again and again. Because of new guidelines, I can't link their site or say it, but you're smart and you can find it with a simple Google search. Stick it to the man by paying them a visit today.
Well, I just submitted my very first gigantic, complex expert witness case, expert witness report. And it ended up being about 140 pages long. It has 37 figures in it. And while I was reviewing some of the discovery for that case, again, before I submitted it, I started thinking a little bit about some of the statements that were made in this particular case. And this is not a particular case. This isn't a case where the individual talked at length with investigators at all, but I've had plenty of cases that have been like that. So let's just review what the EIO principle is. So oftentimes people ask, what do I say after a defensive use of force encounter? What should I say to police officers or responding officers or first responders? And last time we talked about legal principles, we talked about the EIO, the Essential Information Only principle. And that is, I'm only going to be speaking to 911 call takers and first responders. I personally am choosing not to speak with investigators or detectives without my attorney. So a statement that I would make would be something like, I don't want to speak without my lawyer present, but I feel comfortable making initial statements, very brief, essential information only type of statements to first responders. That would be something like my name, and we're going to talk a little bit about more what those things might be. So after we talked about the essential information only principle, Mr. John mentioned and reminded me that it's very similar to the public information statements that police officers make after they're involved in an officer-involved shooting. And so I have an example or a sample statement from an agency on the other side of the state from me. And I won't say which agency it is, but they're actually all very similar. I've researched them, and the public safety statements are very similar across agencies. So I thought I'd just read it to you. It's kind of interesting to me because it says that this is a compelled statement. The supervisor compelling the statement is not to deviate from the contents of the statement whatsoever. They're to ask the questions exactly as written, and they're also to write down the answers provided by the officer that's answering the questions verbatim. They're not to add anything to it or take anything away. So the statement goes something like this: Officer so-and-so, I'm directing you to give a public policy statement to me. And I'm doing that because of the immediate need to take action. You must answer these questions to the best of your ability. And I think it's interesting that they remind them, answer the questions to the best of your ability at this time. And the questions are, from where and in what direction did the threat come from, or did you fire rounds? So from where and in what direction did you fire rounds? And then if the suspect fired rounds, what direction did those go in? And then, is anyone injured? Do you know if anybody's injured? Now, why might those be key questions to ask someone involved in a situation like that? Well, because it's to keep the public safe, right? So what direction did the individual fire in, the officer fire in? Well, they want to check and make sure that all rounds are accounted for so that an innocent bystander isn't hit. Conversely, if the suspect fired rounds toward the officer or from a different direction, where might those have gone? And then asking if anybody's hurt in the location. And then other things they'll ask is, please describe the suspect to us. What did the attacker look like? And that's really about it. From there, then the officers are usually directed to not make any statements to supervisors or to fellow officers. They're typically sent home and asked, and then given several sleep cycles, 72 hours to 96 hours before they make a statement with their attorney present. So, and they'll often explain to the officer that the reason that they don't want them making statements to anyone else is to prevent contamination. They don't want to, if there's other officers involved, they don't want to contaminate the recollections of the other officers. So keeping that in mind, our EIO statement, we can probably think of that as a citizen public safety statement, right? So we would be identifying ourselves and maybe saying, she attacked me, maybe saying how she attacked you, or he or she, whatever, or they attacked me. They had a knife, or they had a gun, or they shot at me, punched or hit me, whatever it is. And then I've had a couple of cases where I can see how it would have been helpful for police to know, responding officers to know, that the individual that was present and in a house, let's say, was not someone that had a right to be there. They didn't have keys to the house, they didn't live there. That might have changed the officer's perception in how they initially investigated the case and in the questions they asked. So, and then maybe telling them, in my case, if it happened in my house, I would want the responding officers to know whether or not my children are home. So my children are home with me and their names are this and here's their ages. That might be helpful to know. So, and then with deep respect, I would always say with deep respect, I would assert my right without escalating at all. So I don't want to say, I do not want to speak without a lawyer present, or I would like to wait to speak until my lawyer is present. I want to say that with the utmost of respect and kindness and deference. So I sparingly communicate who and where. My lawyer does all the rest. I have decided I will not talk to detectives and investigators without an attorney present. I'm going to allow my attorney to do that. So we talked in one of the other, this is kind of part of the series. You have the right versus the responsibility. No, the right versus the ability, not responsibility, the right versus the ability to remain silent. And we talked before about that the risk of sharing information with first responders and detectives is this: 89 to 90% of a state's case against an individual is built by the individual's own statements. And I've seen that happen with my own eyes in my own community. So positively invoking that right, I do not wish to make any statements without my attorney present. We want to positively invoke that right, not just simply be quiet. So I thought I would give you a couple examples from a case that I'm somewhat familiar with. And I'm not going to use the family's real name because they've endured enough. But I will use, and this is not a case that I was a part of, but we'll call them the Jerry family. And one of the things that I've realized in going through discovery for a number of different cases is that oftentimes the questions that are asked by investigators, once they're in case building mode, so when they're building a case, they are the investigators on behalf of the state, and they ask questions that can cast the actions of the defender in a poor light, and maybe even cast their character in a poor light. So an example would be, for the Jerry family, both Mr. and Mrs. Jerry initially thought that the first responders that arrived, were on their side, and they thought that because of officer statements, and officer statements were along the lines of, wow, that was one heck of a shot. And another statement was similar to, hey, we know that person, and you did your community a favor by taking care of him, which seemed like a pretty bold statement to make. And those were statements made by first responders to the Jerry family. Another thing that can happen is when investigators are in case building mode, they can ask seemingly reasonable questions that can make it seem like you're like not honest or you're not sure. And an example would be for the Jerry family, when the first responders arrived, they asked Mr. Jerry where he was standing when he fired the round. They were just outside their house, and the first responders asked, where were you standing when you pressed the trigger? And Mr. Jerry said, well, I believe I was standing right here by the front bumper of the car. And a few minutes later, another officer came by and said, hey, where were you standing when you pressed the trigger? We want to look for any spent casings. And Mr. Jerry said, I told the other officer that I was standing here by the front fender of the car, front bumper of the car, but actually I think I was over by the mailbox. Well, what can that look like? That can look like you're changing your story. And remember, these are just moments after this traumatic event happened. So another question the family was asked is, why did you stay outside? If there was a threat, why didn't you just go back into your house? And the Mrs. Jerry explained, well, when I came out of the house, the door locked behind me and I didn't have the keys. My husband had the keys. And then the question was asked, well, don't you hide a key outside? Well, yes, we do have a key hidden outside, but that wasn't something that Mrs. Jerry had even thought of when the critical incident was happening. So another type of question that's asked is things that can undermine what you did see. So an example would be, so if the officer says, so you just said she lunged towards you. How do you know she didn't just trip? That can undermine what you told them that you saw. You said that you saw him do a witness check. How do you know that there wasn't just something that grabbed his attention over there and that's where they looked? Another type of question that can be asked is they can ask you questions to minimize your attacker's actions. So something as simple as, how could you possibly shoot an unarmed man? He didn't have a gun. Or, listen, the attacker only had a barbecue grill scraper. How could you shoot someone that had a barbecue grill scraper? How could you use a gun against someone that only had a barbecue grill scraper? So you can stop talking anytime and you can say, I would like to finish my statement when my attorney's present. So just know that if you start talking, you can stop anytime. You don't have to keep going. But it's important for us to remember, I think, that the higher the level of force involved, the more we're going to need to have our attorney present when we're answering questions. So adrenaline, remember, is going to make us want to talk a lot. We have to resist that urge to talk a lot. And we talked about some tips. You want to go back and check out the video on logorrhea and how to counteract that, some tips for counteracting that. It's important for us to remember that our first account or our first telling of what happened in the immediate moments of the aftermath of the incident is most likely not going to be complete and it's not going to be accurate. It's best to wait until we've had 2 or 3 sleep cycles for memory consolidation to happen. Waiting until I clearly remember is key because it can help reduce or even eliminate confabulation. And confabulation, an example of confabulation is in the aftermath of a traumatic incident, I might remember point 1, what happened here, and point 3, what happened here. But my mind does not remember how I got from 1 to 3, or maybe, or if there was a point 2. And if I realize, oh, there must have been something that happened between 1 and 3, my brain will actually try to fill in number 2. And it will do that and it'll try to fill it in with something reasonable that makes sense because memory is constructive. But that's when my brain is trying to make sense out of what just happened to me. Over time, a few sleep cycles, as memory consolidates, what actually happened, not all of it, but some of it can be filled in. And then if you don't know what happened, how you got from 1 to 3, you don't know. And it's important to say, I don't know, rather than making something up. Because, for example, with the Jerry family, when Mr. Jerry said, well, I told the first officer that I was standing here, but I actually think I was standing over there. That was used, and several other statements that the Jerry family made were used to make them seem like they were liars, and they weren't lying at all. So when the agency or the investigators are in case building mode, they'll carefully ask you questions that they know have answers that can be used to help indict you or to help find you guilty. But they don't necessarily ask questions that can make it harder to convict you. So in the Jerry family, I won't go into the details of that case because it doesn't really matter. But that case, it was absolutely, I know the individual that was an expert witness on that case, and that was an absolutely righteous and justified use of force. The Jerry family just got incredibly fortunate. Anybody that was on their case or around their case said that the stars aligned, basically. That it very could have easily have gone the other way, but they happened to get the right judge. They happened to use their expert witnesses well, meaning they were able to have the experts help them with motions in limine for using expert witnesses and report writing and question asking and things like that. But that isn't always the case, and we can't always count on the stars aligning perfectly. I surely don't want to count on hope um, in a situation like that. So one of the things I've realized is sometimes these things happen because the truth is that um, sometimes police officers themselves don't actually know what the use of force standards are. Oftentimes, and I'm not saying all of them are like that, but certainly on a number of the cases that I have, that I'm aware of or that I've been involved in, not all of them, but some of them, the officers are confused as to what is a justified use of force. What are the standards of defensive use of force? And I think that's one of the reasons why we'll see officers almost eat each other alive. They'll almost eat their own sometimes in the aftermath of an officer involved shooting. And sometimes it's justified, right? But sometimes the officers don't know about the human performance factors and how they can impact uses of force. If they find out, oh, the suspect was shot in the back, oh, the officer must be guilty, not understanding that there are human performance factors that impact things like that, that can be explained and not explained away, and not but just being honest and truthful about it. Um, One instance I had when I first started doing expert witness work, I come from a law enforcement family. I tried to think if many of my parents' friends were even, if they even had any friends when I was a kid, or even now that aren't law enforcement or retired law enforcement. And I can't think of many. So anyway, I got a call not long after I had my first case, and it hadn't even been fully adjudicated yet. And I got a call from a very, very good friend of mine who was on the police department or the agency that was investigating that use of force. And the officer's name was Mr. Frank. And although he had 20 something years in law enforcement, he was deeply concerned and shocked that I saw the facts of the case as being a justified use of force. He hadn't seen the facts of the case. He had heard, because his office was next to the homicide detective's office, he had heard what other officers were saying about the case, and he couldn't understand how I could possibly see it as a justified use of force. And that was just surprising to me. I didn't realize that by doing expert witness work that it could possibly seen as being adversarial to law enforcement. I personally don't see it as being adversarial. I see it as we're all on the same side, and we're on the side of truth, and we want truth to prevail. And um, so I'll pause with that one. One last reason why I think it's important to have an attorney with you when you make a statement to detectives is because if your attorney is present, they can encourage the investigator or the detective, whoever, to allow you to introduce exculpatory evidence in your initial statement. And exculpatory evidence is evidence that helps your case. So I'm going to give you a silly example of that. But if the investigator doesn't ask questions that reveal the whole story, and your attorney is there and knows the whole story, that can it can be very important to get that information as part of your initial statement. And I'll give you an example of this. So this is not true, but let's say that your grandma's third uncle, twice removed, broke into your grandma's house, and while she was in the shower, and grandma grabbed her palm and blessed the deserving with her hot sauce, and the detective, let's say during the questioning, is making the assumption that grandma assaulted her third uncle, twice removed, because the uncle told responding officers that he lived there at her house, that he had a key to her house, and that he lived there and he helped take care of her. Well, if grandma knows that isn't the truth, she can share that with her attorney, right? And then the attorney can help get that into her initial statement. Listen, grandma has not seen uh, third uncle twice removed in 25 years. She didn't even know he was still alive. She didn't even recognize him. And he doesn't live with her. He doesn't have a key to the house. She did not recognize him until after it was over, and he started um, telling her who he was. So now that's kind of a silly example, but that's an example that it would be important to know for grandma's side of what happened to actually be made part of her initial statement. So that's, if you just offer that as part of your statement, that can be considered hearsay. But if it's a question that you are asked by the detective and then your attorney knows that's part of the record, sometimes that has a more of a likelihood of making its way into um, evidence that's allowed to be shared. And in that case, perhaps charges wouldn't even be filed then, right? If the prosecutor finds out, oh, grandma didn't even know third uncle twice removed, hadn't seen him in 25 years, didn't recognize him, he didn't live there, he didn't help take care of her, there was no assault that happened, they may decide not to charge. Or they might look into it a little bit deeply and find out, well, where has uncle been? That sort of thing. So anyway, I hope this has been a little bit helpful to you. We talked about our EIO statement, initial information only, and why sharing, not initial, essential information only, and why that's important to share only what's essential and let your attorney be the one to speak with detectives and investigators. And then in the next video, I thought I would tell you a little bit about some of the goings on in the expert witness work that I've been doing and some of the things that I've been learning along the way. So we'll do that in the next video. Thanks for joining us, and we'll see you next week.